Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an amazing Saturday. So, this is going to be a Chrisean Malone update in regards to her civil and criminal cases. So, let's hop right on into it. First and foremost, I want to address the sharing of her probation rules and conditions that has been circulating. And there is a lot of misinformation that is going around. At this time, Chrisean has not violated any of her probation terms, rules, conditions, or even special conditions. As you can see here on the portal, this is the Interstate Compact Offender Tracking System. It does show that Chrisean has transferred her probation to the state of Maryland. This was checked off on her rules and conditions on that probation form. So it clearly showed that she had the option, the judge granted her the option to transfer her probation to whatever state she's currently residing in. Okay, so this shows the sending state, Oklahoma, the receiving state, Maryland. So Chrisean is not violating any of her probation rules and conditions. All right. Now, while we are speaking on Maryland, if you do not follow me on IG, uh, I have posted that she has retained an attorney in her Maryland case. The new attorney is Mr. Warren Anthony Brown. I did my research on him, and based off of Google and his AVO reviews, I'm on the fence about him. I've had people inbox me and said he is an awesome attorney. So it just depends on what he's defending. That's what he's awesome at. Everybody have their strengths and everybody has their weaknesses. So we can only see what the outcome will actually be. Now, she still has her hearing scheduled for December 13th, 2024. In my opinion, I don't believe that it's probably going to be postponed because of this. 12/4, he filed his appearance. 12/5, he requested and demanded discovery and inspection. So all of those records, evidence, whatever the state has to be forwarded to his office. He has to review it. He has to discuss it with Chrisean, and he has to talk about their options. I don't think that they're going to have enough time between, between requesting and receiving the records. So, in my opinion, I believe that this hearing is going to be postponed again because he has to be allowed enough time to review the evidence and speak it over with Chrisean and let her know what her options are. Okay. All right. So that is for Maryland. For her criminal case in California against James Wright, I'm not going to pull that up. However, we all know that on June 14th, 2024, she was sentenced to a 12-month probation for the assault against James Wright. Okay, that is still in effect. I did not see any violation hearings or anything reported on that case. So, as of right now, she's doing what she is supposed to do. In regards to her civil case, she has three civil cases in California, one with James Wright, one with LaShayla Irby, which was the hairstylist, and another with Rama. I can't say her last name, and I'm not going to butcher it. So those are her three civil cases in California. So I'm going to go through each one and kind of show you guys where we at on this case. So for the civil trial for James, okay. So as you can see, future hearings, they have a case management conference on was that February 10th, 2025. They also going to discuss the failure to obtain default judgment. And I'm going to explain this because there's a lot of misinformation going out there about when somebody can answer and when somebody can file a default judgment. So I'll explain that in just a second. So on February 10th, they're going to discuss the status of the case, and they're also going to discuss him trying to do a default judgment. So the last time we spoke, we actually went over everything that James had submitted in his declaration in support of the default judgment. He did file his request for entry of default judgment on 10/14/2024. Now, Chrisean has filed an answer on October 3rd, 2024. As I have stated time and time again, that if the petitioner or the plaintiff has not filed their entry for a default judgment within that 10-day period, the defendant has the right to file an answer anytime before that request for a default entry is submitted. All right. Now, here we do show that his request was initially filed on the 9th of, not the 9th, I'm sorry, the 13th of September, but I believe there was something wrong with it, and it was, how can I say, terminated. That request was terminated. So that's why he had to refile. So because it was terminated, that gave Chrisean an opportunity to go ahead and file an answer. All right. So that is what's going on with that case. So as of right now, he has submitted his entry for the default judgment, and they're going to discuss whether or not it's going to, if they're going to grant that default judgment, all because he didn't provide certain information or did something that caused that first entry to be terminated. Another thing with this, they're in the discovery phase right now. So what he has submitted as far as his support for his default judgment was just bills. He did not submit any medical records, dental records that show if anything was medically necessary. He had psychiatrist bills with no therapist, or I wouldn't even say psychiatrist. He had therapist bills with no medical records to back up the amount of bills that, or the amount of the bill that was shown. He produced a bill for the dental records with no medical records showing that it was medically necessary to have, work done on your teeth, and so on and so forth. The defense attorney, Chrisean's attorney, did state that there might be a possibility that they have to file a motion to compel because he is not providing the documents necessary to prove his case. The defense counsel have a right to go through those, and they have a right to contest. So if they see that, something is off about, the medical bills or the medical treatment, that will give them time to even get expert witnesses in that field. So they might get a dentist to look over these records and see if it was medically necessary for him to have this treatment due to what he put in his complaint. So there's a process when you're dealing with discovery. So in this James Wright case, as of right now, they do have a status hearing on February 10th. They're also going to talk about his failure to obtain a default judgment because, as I said, the first one was terminated. He had to refile, but Chrisean's attorney filed an answer before he filed the corrected request for entry of default judgment. All right, moving on to LaShayla Irby's case. Chrisean also filed an answer in this case. Oh, wait, hold up. No, she didn't. She did not file an answer in this case. I misspoke on that one. Looking at my notes. Okay, so future hearings. It does show that they have a hearing on March 6, 2025, to discuss the default judgment against the Baddies Club, to discuss the trial setting, and to discuss where they are at the in this litigation process. The last filing, I forgot what that last order was. Um, and I did see somewhere that they had, oh, here it is. All right. So they actually scheduled mediation for March 6, 2025. So for those defendants, as well as the plaintiff, has to show up and see if they can work out something regarding this litigation case. So mediation has been scheduled for March 6, 2025 at 9 a.m. This is when the defendant and the plaintiffs need to be present. Okay. This is not something, how the process goes. You file the complaint, you get them served, you go through the discovery phase, which includes depositions. Depositions require the presence of both parties and any witnesses that they're going to call. If And then once the discovery period goes, then you go to mediation, because by that time you have all of the documents, you have all of the depositions of all parties involved, and now you're going to work out some type of agreement, and that's where mediation comes in. If mediation does not work, then it goes to trial. That is the process. So the only time either party has to show up is depositions, mediations, or trial. That's it. It's not a criminal case where, and even in some criminal cases, appearance by the defendant is not necessary. The attorney will go on your behalf. So in the LaShayla case, no answer has been filed by Chrisean. She did. Now, I went through the case and I did not see as to where, um, let me see. I didn't see where. I think she did try to submit a request for, yes, she did. The request for a default entry was on, what is that? The 8th, 2024. I think she filed another one. Okay, so this one right here is the one that is against Chrisean Rock, the one for March 25th, 2024. So she did put in a request for a default entry. I know that a few times it was rejected because they didn't complete certain forms correctly, but that is going to be discussed as well. Once again, Chrisean has not filed an answer in this case, and a default judgment was, an entry for the default judgment. It doesn't mean that it's granted. It just means you want to file a notice, you want to file an entry, and the courts will consider that. I don't see any other updates on here other than they are going to have a meeting and mediation on March 6, 2025. All right, last case we are going to discuss is the Rama case. And this is the other case that Chrisean actually has filed an answer to. So here is this one. Here's Rama versus Chrisean and other defendants. So it does show that they have a hearing set for December 30th, 2024. And it's for a number of things. We have one for sanctions. We have one for the proof of service. We have a case management conference and the entry of default for Chrisean. Now, let's see. All right. So Chrisean filed her answer on, what was that? October the 3rd. The plaintiff actually ended up amending the complaint because she sued Chrisean Rock and not Chrisean Malone. So when you file an amended complaint, then you have to go ahead and ensure that this copy of the amended complaint gets to the defendant. So hopefully she has done that. In addition to that, she filed her entry of default judgment to in regards to Zeus. And that's pretty much it. I did not see where she filed a entry of default judgment against Chrisean. That is why Chrisean was able to file her answer uh before Rama ended up filing the entry for a default judgment. Okay. So like with the hairstylist case, as I stated before, there was no answer filed because LaShayla ended up filing the entry for default judgment on Chrisean on the 25th. Okay, so I just want to be clear on that. All right, so that is the Rama case. Now, I do want to discuss because there's a lot of discussion in regards to, well, I don't understand how she gets to file her answer and da 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 da. Okay, here is why. When you are served in California, you have 30 days from the date you are personally served with your summons and a complaint. You have to file a response within 30 days. If it is a substituted service, meaning if they did a citation by publication or they had it where they hang it on your door or serve someone over the age of 16 or older, that will be considered substitute service and they grant you 40 days. And this is according to the California Code of Civil Procedure. All right. So they have 30 days. Now, this is the part that I want y'all to see. The second paragraph. It is not an automatic cutoff date. The court will still accept a response from the defendant after 30 days until the petitioner or the plaintiff files a request for an entry of default. I've said this numerous times, okay? If they have not submitted their request for an entry of default judgment, then you can file your answer until they, well, it's not even until, you can file your answer at that time. Once the clerk enters a default in the court record, the defendant is no longer able to file a response or otherwise participate in the case. So, in the hairdresser case, as I stated, she did not file an answer within the 30 days. LaShayla ended up filing on what I have, March 25th, 2024. Okay, so that is why. It says the plaintiff can also request a judgment entered in his or her favor at the same time as default or later. So this is where you see their declaration in support of the default judgment and blase, blase, blase. All right. Um, that's that. Now, who can request an entry for default? So once again, just to reiterate, this is the process of requesting a default entry for default judgment. If a responsive pleading is not served within the time limits, aka if an answer is not filed in regards to the summons and the petition that was filed, the time limit specified in this rule and no extension of time has been granted, the plaintiff must file a request for entry of default within 10 days after the time of service has elapsed. So that means if it's 30 days, if they were personally served, within 30 days, if they have not answered, after that 30 days, within that 10 days, the petitioner or the plaintiff has to file their entry or request for an entry of default judgment. It then says the court may issue an order to show cause why sanctions should not be imposed if the plaintiff fails to timely file the request for the entry of default. So in James Wright's case, if y'all looked, even though she answered, he still didn't file his request for entry of default in a timely manner. So what happens is that is why you see they have to discuss the sanctions. They have to discuss sanctions. I believe they did that earlier on in the year. Same thing with the Rama case. All right. There was an order to show cause, and it said sanctions because once again, Rama didn't file her entry of default in a timely manner, not just on Chrisean, but for Zeus and the other parties. Okay, so that is why. Hopefully, that clears everything up. So the respondent or the defendant has 30 days to respond to a lawsuit. Okay. It's not a set in stone cutoff date because if they can file it at any time. So it's just like cat and mouse. Who's going to get there before the other person gets there? So that's why we see that Chrisean filed an answer in both the Wright case and the Rama case. It was too late in the LaShayla case because the entry for default was already filed by March 25th, 2024. Okay, so I hope this makes sense. Once again, I am going to keep you guys updated with all of her criminal and civil cases. Uh, oh yeah, I'm about to say comment, but you can't comment because I'm gonna turn the comments off. But if you have a question regarding this, please hit me up on IG. My YouTube IG is Yourfavparalegal_Cassandra. All right. Until then, don't forget to like, share, and subscribe. Y'all be blessed, and I'm out. Bye.